Question 261. When co-owners of a property cannot agree how it should be rented out or sold, the legal proceeding that decides the dispute is called A. Partition action. B. Foreclosure. C. Mediation. D. Remainder suit. Correct answer is a partition action. Foreclosure is a legal process where a lender seizes and sells property to satisfy a debt. Mediation is a process where a neutral third party helps disputing parties reach a voluntary agreement. While it could be used before a partition action, it is not the legal proceeding that decides the dispute. A remainder is a future property interest. It's what someone gets after a life estate ends. A. Remainderman is the person who gets it. A. Remainder suit is legal action taken to protect the rights of the remainderman. A remainder suit relates to future interests in property, not disputes among current co-owners. A partition action is a legal proceeding where a court divides co-owned real property when the owners cannot agree on how to manage or sell it. This is the specific legal remedy for resolving disputes among co-owners. Question 262. The front-end ratio is calculated as the A. Monthly housing expenses divided by monthly gross income, expressed as a percentage. B. Monthly income necessary to meet future projected household expenses. C. Amount of money needed by someone to purchase the front end of a property. D. Both A and C. Correct answer is A. Monthly housing expenses divided by monthly gross income, expressed as a percentage. Front-end ratio, housing ratio, is a key metric used by lenders to assess a borrower's ability to afford housing expenses. It specifically measures the percentage of a borrower's gross monthly income that would go towards housing costs. These costs typically include mortgage principal and interest, property taxes, homeowners insurance, homeowners association, WA, fees, if applicable. Monthly gross income is annual income divided by 12 months. The ratio demonstrates what portion of an individual's income can be used to make mortgage payments. Lenders utilize the front-end ratio along with the back-end ratio to evaluate mortgage applications. Question 263. A party makes an offer to buy a property, which is accepted by the owner. Before the commencement of the escrow period, the fact comes out that the seller is a single minor. Therefore, the contract is A. Illegal, B. Voidable by the minor, C. Enforceable by the buyer, D. Valid, but the escrow period cannot commence until the minor reaches the age of 18. Correct answer is B. Voidable by the minor. Generally, minors, individuals below the legal age of majority, typically 18, lack the legal capacity to enter into binding contracts. Contracts entered into by minors are typically voidable at the minor's option. This means the minor can choose to disaffirm, cancel, the contract, but the other party cannot. The contract is voidable, meaning it's valid unless the minor chooses to cancel it. A minor can only void a contract during his minority status and only for a reasonable time after he reaches the age of majority. After a reasonable period of time, the contract is deemed to be ratified and cannot be voided. Waiting until the minor turns 18 does not automatically make the contract valid. The minor would have to choose to validate the contract. Question 264. If a prospective buyer asks the listing broker whether a previous resident of the property died of AIDS, the broker A. must truthfully answer the question, B. can decline to answer the question, C. refer the prospective buyer to another broker, D. both A and C. Correct answer is B. can decline to answer the question. California Civil Code Section 1710.2 specifically addresses this issue. It states that a real estate agent is not required to disclose that a previous occupant of the property was afflicted with, or died from, AIDS. This law protects the privacy of individuals and prevents discrimination based on health status. Disclosing such information would be a violation of privacy and could lead to discriminatory practices. Question 265. The main types of easement. A. Easement in gross. B. Easement in particular. C. Easement appurtenant. D. Both A and C. Correct answer is D. Both A and C. Easement in particular is not a standard legal term for easements. Easement appurtenant runs with the land, meaning it benefits a specific parcel of land, the dominant tenement, and burdens another parcel, the servient tenement. It's tied to the ownership of the land and transfers with the property when it's sold. For example, a property owner might have an easement appurtenant that grants them access to a private road in order to reach their landlocked property. Easement appurtenant benefits a person or entity, not a specific parcel of land. Examples include utility easements, like for power lines, or easements granted to a specific individual for recreational purposes. It does not necessarily transfer with the land. Question 266. A listing agent can be a seller's agent only, B. Buyer's agent only, C. Dual agent, D. None of the above. Correct answer is C. Dual agent. Listing agents are primarily seller representatives. However, they can become dual agents, representing both parties, with full disclosure and consent. This often happens when a buyer working with the agent seeks to purchase the listed property. To prevent inadvertent dual agency, which can occur through agent behavior and create implied buyer representation, agents must strictly adhere to agency disclosure regulations. Question 267. Which of the following most resembles the relationship between a broker and seller? A. Broker and salesperson. B. Trustee and beneficiary. C. Mortgager and mortgagee. D. Vendor and vendee. Correct answer is B. Trustee and beneficiary. A broker, when acting as a listing agent for a seller, has a fiduciary duty to the seller. This means the broker must act in the seller's best interests, with loyalty, confidentiality, and full disclosure. This relationship closely mirrors the fiduciary relationship between a trustee, who manages assets for another, and a beneficiary, who benefits from those assets. Broker and salesperson is an employer-employee relationship, not a fiduciary relationship in the same way. Mortgager and mortgagee is a debtor-creditor relationship, borrower and lender. Vendor and vendee is a seller-buyer relationship, which is a transactional relationship, not necessarily a fiduciary one. Question 268. For tax purposes, depreciation deductions are based on the A. Value of an asset over its useful life. B. Future contract rent. C. Physical life of a property. D. Actual life of the property. Correct answer is A. Value of an asset over its useful life. Rent is income, not a basis for depreciation. While the physical life of a property may be longer, the useful life, for tax purposes, is often shorter and based on IRS guidelines. The IRS uses set guidelines for useful life, not necessarily the actual life. Actual life of the property is too vague. The IRS uses set guidelines for useful life, not necessarily the actual life. How depreciation is calculated determines the depreciation deduction on a tax return in any one year. For tax purposes, depreciation is a way to deduct the cost of an asset over its useful life. The useful life is the estimated period of time that the asset will be used for business or income-producing purposes. The deductions are based on the asset's cost or basis, spread out over that useful life. Question 269. Which of the following can conduct escrow business? A. A foreign corporation. B. A real estate broker. C. An attorney. D. Any of the above. Correct answer is D. Any of the above. Foreign corporations can conduct escrow business if they meet the licensing and regulatory requirements of the state where they operate. In some states, real estate brokers can conduct escrow services, but they are often subject to specific regulations and limitations. And attorneys can conduct escrow business as part of their legal practice. Therefore, all of the options listed can conduct escrow business, provided they comply with the relevant legal and regulatory requirements. Question 270. In the U.S. Government Survey and Township System method of land description, townships are A. 5 miles in diameter, B. the length of the baseline meridian multiplied by its width, C. 36 square miles, D. the amount varies from county to county. Correct answer is C. 36 square miles. Townships are measured by sides, not diameter, and are 6 miles per side. While baselines and meridians are used in the system, this does not describe the size of a township. Townships are standardized across the system and do not vary by county. In the U.S. government survey system, land is divided into townships, which are square parcels of land measuring 6 miles on each side. Therefore, a township contains 36 square miles, 6 miles by 6 miles.